Hi, my name's Sarah Hayes and I'm an associate solicitor at Paris Smith. I've been at the firm now for around 8 years and I work in the employment department. Under GDPR legislation, employees are entitled to copies of their personal data. We understand that this can be quite an overwhelming and daunting process for employers, particularly where there's large volumes of documents that they need to prepare. However, there are lots of steps that employers can take to be prepared and be proactive with these sorts of requests. We're going to talk you through today our 5 top tips for dealing with data subject access requests. So our first top tip is to ensure that you are comfortable and you understand the scope of the request. Sometimes this is really clear, where the employee has clearly stated what they want, but in other cases you may need to go back and ask for clarification or potentially narrow down the scope of their request so that you really clearly understand what it is that you're being asked to provide and you're clear on what you need to search as an organisation. Our second top tip is to keep track of time. This one's really important. Under GDPR legislation, you generally have 1 month from the date of receipt of request to provide the documents. Whilst that might seem like a long time, in our experience, a month goes really quickly, particularly where you're factoring in lots of people being involved, some people being away on annual leave, and just general time delays. For that reason, it's really important to be proactive with deadlines, to make sure you've diarised when you need to respond by, and that you're keeping on top of those deadlines to ensure you're compliant with your obligations. Where the request is particularly complicated, it may be possible to use a 2-month further extension, i.e. an overall period of 3 months to respond to the request. However, employers should be careful here that you're not automatically relying on that 3-month period, and really you should be responding to requests as soon as possible. Our third top tip is to plan and prepare your DSAR response team. This is a really important one to make sure that you understand who at the organisation is going to be dealing with the request and processing it. Often lots of different people may need to be involved. For instance, you might need to involve your IT team, your HR department, potentially other managers. For that reason, it's really important that in advance of receiving the request, people are clear on what needs to happen if they receive a request in and what their obligations are. It's useful if you can plan this in advance so that everybody's clear on their obligations and it avoids any misunderstandings arising. So our fourth top tip here is to have a process for dealing with redactions and disclosing the documentation. So once you've gone through the exercise of locating all of the personal data, you then need to sift through it to identify, well, what really is personal data and what do we need to disclose to the individual. That can sometimes sound quite obvious, but in reality, identifying personal data can be really tricky. And GDPR requires you here to do a balancing exercise between the rights of different individuals involved. Often what that means is that you'll be redacting the documentation so that you're making sure you only give the individual copies of their own personal data and you're not disclosing the personal data of other individuals that doesn't need to be shared. That process can be very time consuming. It often requires you to go through the documentation, to carefully check through the content and make sure that you're applying those redactions appropriately. There can also be certain exemptions which apply. For instance, if you've received advice from a solicitor, there can be legal advice privileges that apply there, meaning that you don't need to disclose that information. So it's really important to make sure you're familiar with those exemptions as well and how they might apply to your data set. So our final top tip here is around documenting your decision and then really clearly communicating it to the individual. Once you've gone through the process of gathering all the documents and then applying redactions, you're then going to need to provide that data set back to the individual that's made the request. As part of this, you're going to need to confirm to them what you're disclosing, any exemptions that you may have relied upon, so that you can clearly communicate the process that you have followed. This is also really helpful so that if the individual does complain, you can show to the Information Commissioner Officer, the ICO, the process that you've followed, and that's hopefully going to minimise the risk of any disputes or complaints arising as well. As a firm, Paris Smith has access to some AI software called Smartbox, which is designed to help you with processing these sorts of requests. We understand that they can be very tricky with lots of documents involved. The idea is that using Smartbox, we can take oversight of this process for you. We can streamline the documents for you. We can apply redactions, ultimately giving you a more manageable process and a set of documents you can provide back to the individual in compliance with your legal obligations and the timescales that are involved. As a team, we also regularly deliver training on all sorts of employment law issues, including GDPR and data subject access requests. If this is something that you're interested in or would like to find out more information about, please do get in touch with any member of the employment team and we'd be happy to discuss that further with you. I hope you found our 5 top tips useful, and if you do have any queries, please do not hesitate to get in touch.